My name's Deputy Inspector General of Police, Dr. Shehu, PSC. To talk about PRAWA, Prisoners Rehabilitation and Welfare Action, we have a very, very good rapport, good understanding, and good synergy between the police and PRAWA for many years. It is an institution that concerns primarily on respect of dignity and human rights, which the police are supposed to be part of it. And also capacity building to the police to enable them to perform effectively and efficiently in conjunction with the fundamental respect to the fundamental human rights as enshrined into the Nigerian constitutions of 1999. It's very, very beneficial, and at the same time in building capacity and enabling the police officers to perform credibly when they go out to discharge their duties. The police is an organization that deals with all kinds of human beings. When they come across a police officer, they deserve to be respected by police in ensuring not only their security and safety, but also in respecting their dignity and human rights. So in a nutshell, the training and retraining we are getting from the PRAWA is to enable us have police that will function and discharge their duties in a most standard and acceptable manner by members of the public. At this juncture, I want to say kudos. Welcome to the Nigeria Police Force online training.
Thank you very much for signing on this particular module, which is discussing police search and seizures. And we are still dealing with the same course, our course on guidelines for selected police interventions. I want to start by saying that police search and seizures, it's something that every police officer should really be very conversant with. In terms of the guideline leading to this is a very important module, and I want to recommend that everyone should indeed undertake this module. Now, what is our lesson objectives? We want to ensure that we promote greater understanding of the application of human rights in respect to the discharge of your duties in relation to police search and seizures. In terms of the expected outcome, we want you at the end of this training to be able to exhibit greater knowledge of the guidelines for good practices in the exercise of police search and seizures that you may undertake. Now, as a way of introduction, I want to first say that search and seizure operations are very critical in the conduct of investigations, in evidence gathering, and in preempting possible criminal activities or threats to public safety. However, it's clear that maximum care should be observed in search and seizure to avoid human life violations, and then to avoid committing other offenses or actually having the operation in terms of investigation being hampered. So what we do, how we do it, is very important. Now, if we look at Article 12 of the Universal Declaration on Human Rights, it tells us certain things about the right of individuals not to be subjected to any kind of interference. The issues, it speaks about issues relating to privacy, relating to how we treat people's houses, correspondence, and all the rest of that. So the key thing here is that people have the right to their own privacy. Okay, so it's important to know that, and that is contained in Article 12, as I said, of the Universal Declaration of Human Rights. Now, if you also look at Section 37 of the 1999 Constitution as amended, you will also see certain similarities with the point I had made about Article 12 of the Universal Declaration on Human Rights. That section also speaks to about privacy of person. So, in the interests of defense, public safety, public morality, or public health, these are the only sections when this right can be actually, circumstances where this right actually can be restricted. So please again look at that Section 37 of the Constitution of Nigeria. Now, for the purpose of protecting the rights and freedom of persons, these are all exceptions, yeah? The exceptions to this rule. So maybe I should first go take it a little bit. Let's take it a little bit deeper. Remember, I first started by mentioning Article 12 of the Universal Declaration of Human Rights, okay? And then I said to you that there is a link between that Article 12 of the Universal Declaration of Human Rights and Section 37 of the 1999 Constitution, okay? So let's look closer on that Section 37. Now, if you look at the Section 37, it talks about the privacy of citizens, their homes, correspondences, telephone conversations, and telegraphic communication is hereby guaranteed and protected, okay? Now, the provision of Section 37 of the Constitution has circumstances in which these fundamental rights can be restricted. And that was the point I was trying to make. They can be restricted, and in what circumstances can they be restricted? That's what I want us to look closely on. Now, also look at Section 45 of the Constitution. That Section 45 of the Constitution provides that nothing in Section 37, which was what we said earlier, Section 37, Section 38, Section 39, and indeed Section 41 of the Constitution shall invalidate any law that is reasonably justified in terms of a democratic society, whereby some of these things have to be restricted. And what are those things? Please note those points I'm making here. 1, in the interest of defense. 2, in relation to public safety. 3, in relation to public morality. 4, in relation to public health. There are also something says, so you now say now, or B, for the purpose of protecting the rights and freedom of other persons. So in other words, they can restrict these rights when other persons' rights are likely to be violated. Okay? So this really is just to make that provision. So don't forget to go through these exceptions. Don't forget to read also Section 37 of the Constitution. Don't also forget to read Section 2, Article 12 of the Universal Declaration of Human Rights. So all I need to tell you up front is that for every situation where you are taking any action that actually restricts these rights of privacy, these rights, you must make sure that those times actually can be explained by any of the exemptions that we have just discussed, okay? Now, let's quickly move into the issue around search. What is search? How can we define it? Black's Law Dictionary, and I'm talking specifically the 7th edition, has this way to actually define search as does. It says that it is an examination of a person's body or property or other areas that the person would reasonably be expected to consider as private. Do you understand the point being made here? So, there are two things that you should bear in mind as officers. if in terms of our understanding of search, the concept of search. It says that obviously this have to be either be a search on somebody's body or on somebody's property or on any particular area that this particular person considers private. So the 2 point is, does this person consider this thing as private? And all these areas, are they those that the individual can lay claim over? Okay? Now, and it is when you look at that, then you can better understand Article 12 and Article 30, Section 37 of the Constitution, Article 12 of the Universal Declaration on Human Rights, and Section 37 of the Constitution in relation to the notion of right to privacy. So there must be a consideration that this is private to me, because if that consideration is not, then that right will not be said to have been infringed upon. Now, the object of the search is to obtain evidence. Don't forget that. The object of the search is to obtain evidence that may be used in the prosecution of a criminal trial. So search can be on a person or on a premises or on properties. Okay, I think that's very clear. Now, let's talk about the different types of searches. The first one I would like us to look at is search of person. A police officer making a lawful arrest has the power to search the body of the person being arrested, okay? He needs not give the reason for the search. A private person who has custody of an arrested person also has the power to search the person. I also want to remind us of Section 29 of the Police Act, which empowers an officer to search someone who they reasonably believe has a stolen property with them. Don't also forget to look at Section 150, subsection 1B of the Custom and Exercise Management Act, that is Cap 84, Volume 5 of the Laws of Federation of Nigeria, 1990. However, this power is restricted to specific custom areas, like, for example, the borders or airports. It is also important to mention very clearly that when the suspect is a woman, the officer that is supposed to do that search should be what? A woman. Please don't forget that. And the search here is really restricted to the search of the person and not in terms of the search of the things pertaining to that person. So please, let us make sure that we are following this issue. So we've discussed the issue about the search of persons, so let's talk about search of premises. A search warrant must be procured before embarking on the search of any premises. It would be unlawful to do so without a search warrant. If we look at Section 147, Sub 1 of the Customs and Exercise Act, it authorizes the search of a premises by a custom officer without a search warrant. And also, Section 85 of the CPC authorizes a justice of the peace to direct a search of a premises in his presence. Okay? A search warrant. This is an order in writing which is issued by a judge or a magistrate or a justice of peace in the name of the state. And this particular order directs a police officer, okay, to search or seize any property that may constitute an evidence for the commission of a crime properly intended or for the use as a means of committing crime. The search warrant may be directed to one or more persons. And this is actually as contained in Section 110 of the CPA. Okay? Note, before a police officer exercises this power, this is this power that we have mentioned here, he should inform the person of this suspicion and belief and give ground for the belief. Where the procedure is not followed, it can be a ground for resisting the search and also a good defense. Let me explain what is happening. Remember that we started by saying that it is the judge the magistrate or the justice of peace that can authorize now the officer to search and also seize any property. So, Section 110 of the Criminal Procedure Act. Okay? Now, we mentioned here that the police officer in exercise of this power must also inform the person of his suspicion of belief and the grounds for this before embarking on this. And if the point that is made here in Ondora versus COP is that, and that is a 1960 case, is that this can be a good ground, for resisting the search. And it would be a good defense. That is if the officer did not explain. Okay? And don't forget that I said that this power is contained in Section 110 of the CPA. Now, the next thing I would like us to look at is how do we procure a search warrant? It is procurable upon information on oath, and it must be in writing. Section 107 sub 1 of the CPA and Section 76 of the CPC. Both provide that where a magistrate is satisfied by information upon an oath and in writing that there is reasonable ground for believing that there is in the state, in any building, a ship or carriage, receptacle or place, anything or in respect of which any offense has been or is suspected to have been committed, or anything which there is reasonable grounds, I'm emphasizing that, reasonable grounds for believing will afford evidence as to the commission of any offense, or anything which there is reasonable ground or believing is intended to be used for the purpose of committing any offense. The magistrate may at any time issue a warrant called a search warrant, which authorizes the officer or officer of the court, or authorizes a member of the police force or any other person that is named in that warrant to search such building or such ship and etc. Okay? So it's important that we bear this clearly in mind and follow through in terms of our practices, our actions, or operations in terms of search, to make sure that this actually fulfills all the ingredients that is fulfilled, that is stated here. Okay? And maybe I should mention also the last part, which is that to apprehend the occupier of a house or place where the things was found, if the magistrate deems fit so to direct on the warrant. Meaning the warrant can just be, you go and search this. But the warrant can also be, with something that really indicates that you could also apprehend the occupier. And in this regard, you are now seeing arrests also are being applied to get it. So you can, in the bit of arresting, seize the property as well as do what? Arrest the suspect. Who issues a search warrant? Of course, we've mentioned it's either the judge or the magistrate. Okay? And then we've made the reference this year. Don't forget the point made about the justice of peace earlier. We've also made some references here. Please take your time to read Section 109 sub 1 of the CPA, Section 76 sub 1 of the CPC, Section 109 sub 2 of the CPA, as well as Section 108 of the CPA. Okay. Yeah, I think we need to look at closely the effect of wrongful procurement of a search warrant. Going by the case of Kuku versus Olusoga, which is a 1962 case, one of the key things that were decided in that case is that if a wrongful procurement of a search warrant occurs, this actually renders that search warrant unlawful. So please note that. Now let's also look at the issue about time of issue or execution of the search warrant. A search warrant may be issued on any day, including even on a Saturday or even a public holiday, though the time of execution of that warrant is something that you need to note. Very important, the position of the law on it. Now, it is restricted to 5 a.m. to 8 p.m. 5 a.m. to 8 p.m., meaning that if you then execute that search warrant, say by 10 p.m. or 9 p.m., that may actually become a problem. However, the court may use its discretion to allow it for 24 hours. That is, it can then be executed at any time if that warrant so endorses this. Okay? In the CPC section 74, it is stated that the search warrant can be issued by a court or by justice of the peace. Please do not forget that point. Now, I just want to state that the CPC is not as specific as the CPA when we look at the issues relating to how to apply the search warrant. And I'll give you some few examples. In the CPA, it is clearly stated that the warrant must be in writing and it has to be on oath. I also want you to look at section 75 and section 76 of the CPC, which provides for search in relation to stolen property. The other section I would like you to look at in the CPC is section 78. And here it is stating that search should be done in the presence of two respected persons. Now, note in the southern part of the country, the owner of the premise may actually search the policeman before, the police officer before he or she conducts the search. And the reason for this is really to prevent any allegation that the officer planted something in the suspect's place. Okay? Now, look clearly at the following sections, and I encourage you during your spare time, go and review these sections. Section 78, especially subsection 2. Also look at section 79, section 80, section 81, section 82, and section 84 of the CPC. Okay, so let's look at search warrant under the Police Act with clear reference to section 28 of the Police Act. This allows the superior officer to issue a search warrant in certain circumstances. So, and these are, for example, if the thing to be recovered in the premises is a stolen property, or the premises, or that the premises are or have been within the preceding 12 months in the occupation of any person who has been convicted or who is being said to be receiving stolen property, or harboring thieves, or any other offense involving dishonesty or involving fraud, that needs to be noted. Please note this very carefully. A superior police officer is defined in section 2 of the Police Act as an officer being above the rank of a cadet assistant superintendent of police, ASCP. Okay? So, in terms of search with warrant, a search with warrant will normally authorize the search of a specific person or a specific premises or a specific article. It has to be very specific. Where the operation allows this opportunity, it is always better to search with warrant than without warrant. It's usually better. When a police officer wishes to conduct a search, he or she must normally have a pre-issued warrant to enable that search and to occur. This is a basic safeguard for the rights of individuals and to ensure that the police officers act lawfully. So this is again, yes, you have the right, you have the power to search, but when you have search with a warrant, it actually provides the guidelines and the processes that needs to be undertaken. For example, as we have been mentioned earlier, what particular person or what specific person needs to be searched, what specific premises needs to be searched, what specific article needs to be searched. Search warrants can be obtained, as we have said severally here, either by the judge, by the magistrate or the justice of peace or the commissioner of police. That is a combined application of both the CPC and the CPA. Now note, before any search, the officer that wants to conduct the search have to present himself, to be searched. That especially in the terms of the South that I have mentioned earlier, by the occupant, and clearly to make it sure that people know, look, I am not coming here to plant any incriminating object. Okay? Now, the other thing I want to mention is that in terms of looking at the procedure that needs to be followed in terms of conducting a search, we should note the following in addition. A warrant will normally be executed by day. We said that before. I'm reminding you again about it. Unless otherwise stated. So if it was not stated that it is going to apply for 24 hours, or no time had been specified, remember that it will be between 5 a.m. and 8 p.m. Okay? Now, and in that case, a good reason must have been given why it needed to be done at night or at any other time. So make sure that if there's any reason why you need the search warrant to actually be activated, or why you need the search outside the specified time of 5 a.m. to 8 p.m., make sure that you bring this clearly stated this before the court and for the judge or the warrant or the magistrate. A warrant will normally be enforced until executed, unless cancelled by the person who issued the warrant or a person with the same authority. This is a point I would also don't want you to forget. After a search has been executed, all the items that were recovered should be listed on the warrant, and a witness should sign the warrant. This will normally be the owner or the occupier of the premises. And you and I clearly will understand why this is the case. So that we don't run into an error, a situation whereby maybe 12 items were taken and the person will say, no, you came in and took 20 items. So it is clear that you indicate what had been taken and let the occupier sign that off. A warrant should be executed only within the strict specifications that have been mentioned in that warrant. Okay? Such must, as a general principle, be conducted in the presence of the owner or the occupier of that premises. A search can also be conducted without warrant in a matter of urgency. Also, if under a specific legislative provision that these actually have been covered, that means that legislation have indicated that such can happen without warrant, then that is when you can also apply search without warrant. Okay? Now, maybe we should spend a little time to look at the conditions that need to be precedent to execute a search warrant on either a building or a property. And this specifically, I would want us to bear in mind section 111 sub 1 of the CPA, where the following have also been indicated. So, 1, a search warrant may be issued and executed on a day which may include a public holiday that we have said earlier. And then, well, it is also stated that for it to be executed, that the following must be actually happen. That a law enforcement agency or agent or officer need to procure the warrant from an appropriate authority. And we have earlier on stated what those appropriate authorities are, if you remember, the judge, the magistrate, the justice of the peace. And then don't forget the point about the fact that the commissioner itself can also issue in terms of if those criteria that we had earlier mentioned apply. Okay. Let's look at perhaps the rights of persons whose property or buildings are being searched. The first right I want you to note is the search. They have the right for the search to be conducted in the presence of witnesses. Okay. The second is the fact that the right of a woman whose quarter of building is being searched, where any of that place to be searched is an apartment, actually, that is a woman that is occupying it. There are laid down procedures that need to be mentioned. Okay, so if you look very carefully at what is stated here, you will understand that it's talking about what you need to do. And then let me just take it up. It says, for example, the issue whereby the person making the search shall, before entering the apartment, give notice to such a woman that she is at liberty to withdraw and shall afford her every reasonable facility for withdrawing. This is important, and I think we will understand why this is need to happen. And this is something that I would encourage every police officer that we should actually understand and also apply. Okay? The search of a person found in a building or a premises being searched. Yeah? Where a person is found in such a building or in such a premises, and that person is reasonably suspected to be concealing, somebody else or concealing any other article, such a person may be searched. But he has a right to the copy of the list of any item found or seized from him or her. Let me give an example. You go into a particular building and you're searching that particular premises, and then there's somebody who you suspect is probably holding something that you are looking for or something that you think will be a material evidence in terms of proving your case. You can also search that individual. But the point here being made is that whatever you seize, that the person must have a list of what has been seized through that search. The other point I want to mention here is that the occupant of a place search, that the occupant of a place search or some other person on his or her behalf shall be permitted to be present at the search and shall be entitled to the same list. We've said that before, but I'm repeating it again. And then, of course, they shall duly sign the list also by the witness, the people who are witnessing that process. So, in regard to this, look at your CPC. I would encourage you to look at CPC section 80. I'm also going to encourage you to look at section 82, which we're going to discuss a little bit more now. And that section 82 of the CPC is saying that whenever it is necessary to search a woman in the process of executing a search warrant in a premises, that woman shall be entitled to be searched by another woman with strict regards to decency. Okay? With strict regards to decency. So, in looking at some of these things, one of the things I would like you to be thinking and reflecting is that what are the provisions put in place that tends to respect the rights of women, or that tends to respect the rights of the occupant in terms of human rights, in terms of their right to privacy, their right to actually have a copy of whatever it has been seized from their premises. So let's keep reflecting on that. Okay, let's discuss the topic, the issue about seizure. And let's start. What is seizure? What does it mean? Let's look at the Black's Law Dictionary, where seizure is defined as the act or an instance of taking possession of a person or property by legal right or by legal process. So you are seizing something, you are taking something that is supposed to be in possession of somebody else, or taking either a human being, or you're taking a property that relates to that person. But the key point here is that a legal process must follow. So it is the legal process that actually distinguishes it, that makes it that's the entitlement to effect that seizure. Now, search warrant ordinarily gives power to seize, although only goods mentioned in the search warrant should be seized. This is important. Only goods mentioned in the search warrant should be seized. There are authorities to the effect that where the person executing the warrant come across goods which he or she reasonably believes that have been stolen or are relevant in respect of other offenses, he or she can lawfully seize such goods. This point was actually made in the case of Reynolds versus Commissioner of Police for the Metropolis, and this is a 1985 case. Please find time to look through sections 113 of the CPA, sections 114 of the CPA, as well as sections 115 and sections 117, to just enable you to know a little bit more. Also look at section 117 of the CPA, look at also 115 more deeply in terms of understanding some of these points that I have made here. So that's part of what I will encourage you to use as part of your revision on this card. I want to talk about the issue of admissibility of evidence illegally obtained. admissibility of evidence that is illegally obtained. Now, please note this point very carefully. Where a document or any other materials have been seized from a premises of another in circumstances that render such removal unlawful, such documents may notwithstanding be admitted in evidence at the trial where they are relevant. This is because the basis of admissibility of any evidence is its relevance. Okay? And this point was actually made in the case of Musa Saadu versus the state, as well as Kuruma versus the Queen. This is in case of 1955 case. But please, as you are noting this point, in terms of the admissibility of evidence, which means the importance of that admissibility, the important point I need to really prove is the relevance of the document. At the back of your mind, I also want you to bear in mind that if it is in terms of looking at admissibility of an evidence that was taken through torture, it will be a different issue that will be applying here. So this is barely talking about document, and the issue of relevance is what is being put here. Now, let us flag some of the points that we had mentioned earlier, but just mention this maybe in a formal way. I want to state this is in terms of a summary of some of the things that we've learned in terms of searches and seizures. First, a search and seizure operation is allowed and it is legal. Don't forget that. And this is only so when it is covered by a valid search warrant, which has been issued by the court. And we know in the sense of the court is either the judge or the magistrate. We also know about the role that the justice of the peace can play. Don't also forget the right of the Commissioner of Police to issue this in relation to specific cases, as earlier been mentioned. Normally, a search warrant should be issued only during the day. We have mentioned that, and that when this is not the case, that is day between 5 a.m. and 8 p.m., that this needs to be covered in the warrant or stated in the warrant, and it could be at any time. It could be for a 24-hour period, or at any other time that is also clearly stipulated. But if it is not stipulated, we are bound to comply with the 5 a.m. to 8 p.m. time frame. The search warrant must show or indicate the signature of the judge, the specified alleged violation or the crime, the exact address or location of the area to be searched, and the exact items to be seized. The search warrant is only valid for 10 days from the date it was actually issued, and it is as valid as it is actually executed. The police officer must be in proper and complete uniform. Don't forget the points we studied around this earlier, which would include the plate number, the ID number, and all the rest of that. The police officer must also identify himself or herself and must show that the search warrant, must actually identify himself or show himself to the owner of the property and all the rest of that. So please note this point that we have mentioned. And then we also said that when the owner refuses to cooperate or denies the officer entry, that the officer can actually forcibly also enter the property. Now, we also spoke about the issue of having at least two witnesses in some instances to be able to be present. We also talked about the issue relating to what you do when you see somebody else that you believe have concealed an item that needed to be seized, or item that you believe that you are looking for, but that in that case, the list of what you have taken must also be indicated. Now, in a pat-down search, officers are permitted only to feel the outer clothing of the suspect. Officers may not place their hands in pockets unless they feel an object that could possibly be a weapon, such as a firearm or knife or a blunt instrument, is actually being held at that time. So please note all these points that we are making, okay? Okay, in conducting a pat-down search, as much as possible, only female officers should be allowed to frisk a female adult or minor, okay? only female officers. Remember, only female officers should be able to freak the female adult or minor. Also, remember the point that was made about a female searching a female earlier. During the conduct of a pat-down, a full custody search is allowed when a police officer discovers that a person has in his or her possession an illegal weapon or an illegal drug or narcotics and all that, on prohibited items and all that. The police officer must fully inform the arrested person about his or her rights. When an individual or group is uncooperative or resisting arrest, they should also apply the principles that we have discussed in terms of use of force. Don't forget those principles. The plan principle of graduating or moving of that force in terms of continuum, the issue about proportionality, legality, accountability, and necessity, the issue about minimum force, and the issue about reasonableness in terms of how you make the judgment as to what force should be applied. Let me also mention some other fewer things, like illegal items or contraband may also be seized by the police officer, if these are not covered in the search, as long as the said item are in plain view. Okay? Police officers or members of the search party are required to present an official receipt of all the items that are seized. The point that is being made here, remember the earlier point says that the items that will be seized need to be captured in the warrant. However, if these items that you suspect will be contraband or suspect will be a material evidence or suspect will be relevant to the case in question and is within view, you can also seize it. But in this regard, you must document what has been seized. You must give a receipt to the owner of what you have taken. Now, after arresting a person, the police officers can fix the arrested person and conduct search and seizure in terms of any illegal item or material that they think can be used, or that they think would be relevant also in terms of dealing with the matter, or that they think will actually pose a threat to the police officers or to the general public. Now, all officers must promote and protect human rights. In doing that, you must have full understanding and appreciation of the citizens' right to be secure in their personal homes, the citizens' right to their property, and the citizens' right to be free from unreasonable or illegal searches and seizure. So again, it looks like we've taken a lot of time in discussing searches and seizures, but this is very important. So what I will encourage you is take your time, go over what we have studied, look at your manual, and please, when you go out, let your actions, let your operations in relation to these issues be different. Let it be clear that now you are an officer who have actually done human rights training in relation to search and seizure. Thank you again for signing on this particular training.